Welcome everybody to this book launch. I have the book also with me. It is really a privilege for me to chair this launch of the much anticipated 4th edition of The Law of the Sea by Robin Churchill, Vaughan Lowe and Amy Sanders. On a personal note, this is a particular pleasure for me as the earlier editions of this key textbook in the Law of the Sea played an imperative role in my first studies and my later practicing and teaching of the Law of the Sea. And I know many of you share this experience. The 3rd edition of the book is from 1999. Obviously, in the 23 years that have passed, there have been considerable developments in the Law of the Sea, among other things due to advanced science and technology, and changing environmental circumstances. It is interesting to note that the Law of the Sea Convention has never been formally amended, but the Law of the Sea framework has found other ways to develop and adapt to new challenges. This is reflected in the size of the new, very comprehensive 4th edition, which has 900 pages compared with 500 pages of the earlier edition. I know the authors do not require much introduction, but for the sake of good order, Robin Churchill is Emeritus Professor of International Law at the University of Dundee. Vaughan Lowe is QC, is Emeritus Professor of International Law at the University of Oxford. And Amy Sanders is a barrister at Essex Court Chambers. Robin and Vaughan were responsible for the first 3 editions, but Amy has now ably joined them as co-author. The authors will now make short comments about different contents of the book. Following that, they are happy to respond to questions from the audience. And I ask you please to submit short and clear questions on the chat. If required, we may be able to go slightly beyond the 1 hour, just a few minutes, so it's not too rigid. Now, Robin will start, and he will make a general introduction to the book. Robin, please.
Thank you very much, and I'm sure I speak on behalf of my co-authors, and I'd like to thank you most warmly for taking time out of your busy schedule to host this book launch. As you mentioned, I'll say a few words about the new edition, and as you also mentioned, it's grown by some 400 pages, and I'd like to explain in a way why this is. It's not simply a middle-aged spread. It is the fact that there's been so much development in the Law of the Sea since the 3rd edition was published in 1999. If we think back to that edition, when that was published, the 3 institutions that the convention establishes had hardly begun to function. The International Seabed Authority had done very little of note at that point. Now, of course, it's adopted 3 sets of regulations on exploration and various other measures, and Amy will be talking about those later. The Commission on the Limits of the Continental Shelf, the 2nd institution established by the Convention, had, at the time of the 3rd edition, not received a single submission to establish limits of the continental shelf beyond 200 miles. Now it's received some 90 submissions, which I think is far more than we anticipated at the time of the 3rd edition, and it's issued some 35 recommendations, which is probably a slower pace of recommendations than many of us might have thought. And then lastly, but not least, the International Tribunal for the Law of the Sea. At the time of the 3rd edition, it had given just 1 judgment, which was the prompt release decision in the Saiga No. 1 case. And since then, we've had some 30-odd rulings, a mixture of judgments on the merits, judgments on jurisdiction, judgments on prompt release, provisional measures orders, and 2 advisory opinions. And as well as the tribunal, there have also been a number of decisions, some a dozen or so, from tribunals established under Annex 6. And outside the framework of the Law of the Sea Convention. Then we have the a dozen decisions or so of the International Court of Justice and some 3 or 4 arbitral awards. Some other developments relating to the convention since the 3rd edition that are worthy of note. First, there is the ongoing Intergovernmental Conference on conservation and sustainable use of biodiversity beyond the limits of national jurisdiction. Originally, that was scheduled to finish before we went to press, which would have made things easy, or relatively easy, in terms of covering it. But we went to press after the 3rd session, at which point there was a draft convention. But the convention is absolutely crammed with square brackets of alternatives to various articles. And it would have been impossible to try and summarize that in any meaningful way, and probably would have been out of date by the time the next session of the conference takes place. So it's been a challenge to cover that really, and we haven't said a great deal about it. And then the other thing I would mention relating to the convention, again since the 3rd edition, is we now have a much better idea of how the annual review of the convention operates. Indeed, one element of the review, the informal consultative process, has actually been developed since the 3rd edition. But we have a much better idea, I think, about some of the other elements, that the meetings of the state parties is not going to develop into anything like a kind of COP or MOP, Conference of the Parties of a Marine Environmental Agreement. But nevertheless, it has adopted a couple of decisions which have de facto amended the convention relating to the time limits for making submissions to the Commission on the Continental Shelf. Then I think we appreciate much more now the significance of resolutions of the General Assembly, the annual Oceans and Law of the Sea resolutions and the annual Sustainable Fisheries resolutions. These resolutions had stimulated both new treaties and arguably the development of new customary law. And we also argue in the book that at least some of these resolutions may be taken into account in interpreting the convention in the form of subsequent practice of the parties, even though there isn't a complete identity between the parties to the convention and the members of the General Assembly. Apart from developments relating to the convention, there have been a host of other developments relating to the sea, law of the sea, several multilateral treaties, some from the IMO, the UNESCO's Underwater Cultural Heritage Convention, and so on. Many important regional agreements, new protocols to the regional seas agreements, new fisheries management organizations established by treaty. There have been many decisions by international organizations which have to be taken into account, both those representing hard law, but also increasingly soft law from bodies like the Food and Agriculture Organization, the FAO, and from the Memoranda of Understanding on Port State Control. Many official reports have also been published which are really valuable in showing how the law operates. For example, the annual reports of the Paris and Tokyo Memoranda on Port State Control contains a wealth of information about flag states, defective ships, and so on, all of which we've tried to take into account to some degree. Another example would be the review performances of regional fisheries management organizations, which again are a host of information about the practical operations of these kinds of bodies. Since the 3rd edition, there are some themes which I think were mentioned or are mentioned in the 3rd edition, which the significance of which has become much more important. One is the impact of other branches of international law on the law of the sea. I'll just give you a couple of examples. Human rights have become much more important in relation to the law of the sea in recent years. It's become evident, if it wasn't before, that law enforcement activities at sea, the arrest and detention of vessels, have to comply with the due process requirements found in international human rights treaties. And there are, for example, a number of important decisions of national courts in Europe applying the European Convention on Human Rights to the arrest and detention of suspected Somali pirate vessels. Again, international trade law is having an impact on law of the sea. It's much more significant now in terms of a right of access to ports or a right of transit for landlocked states to access the sea through the territory of other states. And in other ways that one might not have expected. One might not have expected, for example, that the WTO would have become involved in the important question of fisheries subsidies, which are one of the drivers of illegal fishing. Unfortunately, the WTO has not yet reached agreement on that, in spite of the fact that various deadlines have come and gone, a feeling with which the authors of this book, I'm afraid, are all too familiar. All these developments that I've outlined very, very briefly have, of course, not only increased the size of the book, they've also affected the structure of the book to some degree. Readers who are familiar with the third edition will discover that some chapters have been restructured to a greater or lesser extent, and the later chapters in the book have noticeably changed. In the third edition, there was a single chapter, a very long one, on marine pollution and protection of the marine environment, and that's now been split into 3 to reflect the increasing importance of the need to conserve biodiversity. Everyone is familiar, of course, with the reports of the Intergovernmental Panel on Climate Change, but the equivalent body for nature and ecosystem services is less well known, but published a significant report in 2019, which shows how badly affected the natural environment is both on land and at sea. And that certainly has increased the need to consider much more carefully and fully the need to conserve marine biodiversity. So we have a separate chapter on that, which we never had before. The chapter on military uses has gone, partly for reasons of space, but also because some of it wasn't directly concerned with the law of the sea. But some of the material that was there is now found in other chapters, for example, in the EEZ chapter, and the question of what military activities can be carried out by foreign warships in the EEZ. And one final point to mention, and then I'll stop, is sea level rise was something we knew about in 1999, but hadn't appreciated perhaps as fully the impact it will have, or rather I should say the impact that increased emissions of greenhouse gases are having. Sea level rise affects the law of the sea in terms of baselines, potentially in terms of maritime boundary agreements, and the warming of the seas resulting from emissions of carbon dioxide and other greenhouse gases is causing the migratory patterns of fish to change, which has implications for both the species managed by regional fisheries management organizations and for shared stocks agreements. Sorry, I've gone a couple of minutes over time, I'm afraid. Thank you anyway.
Thank you very much, Robin, for an excellent general introduction to the book. Next, Amy Sander will discuss the international seabed area and some issues related to deep seabed mining. Thank you. You have the floor, Amy.
Thank you very much indeed, and good afternoon to you all. Yes, so today I'm going to talk about chapter 12 of the book, addressing the international seabed area. Defined in UNCLOS as the seabed and ocean floor and subsoil thereof beyond national jurisdiction. This is an almost otherworldly oceanic abyssal plain, featuring seamounts and hydrothermal vents, far beneath the surface, dark as night, and covering a somewhat staggering 50% of the total area of our world's oceans. It is a topic which hits at the intersection of creative evolution of the legal framework, cutting-edge technological advancements, scope for accumulation of power and wealth, and potential for irreversible damage to this vast and fragile marine environment. I'll begin by making some comments on the process of updating the chapter, and then touch on some issues to be grappled with. So, the update. The original chapter in the first edition was 20 pages long, and the chapter in this fourth edition is 40 pages long. Whilst we all know that page length does not necessarily tally with quality and content, we hope you'll agree that here it does. So, why the increase? The legal framework, Part 11 of UNCLOS, Annex 3, the 1994 Implementation Agreement, was and remains addressed in the initial sections of the chapter. What has evolved, of course, is the activities of the International Seabed Authority. I'll refer to it as the authority, the organisation mandated by UNCLOS to organise and control all mineral-related activities in the area. I summarise three key aspects. First, there are the regulations issued addressing prospecting and exploration of polymetallic nodules, sulfides, and ferromanganese crusts. These rather technical sounding labels denote elements used in batteries and green metals used in low carbon technologies such as solar power plants, which, given our current trajectory to a global temperature of 3.2 degrees by 2100, are considered a sought after commodity. To give some colour to what sought after means in this context, one of the companies exploring such minerals, Deep Green Metals, on announcing last year a merger with SOAC to form the Metals Company, gave a valuation of that company of nearly $3 billion. However, and whilst the recent Russian invasion has given the impetus for calls by some to securing alternative mineral supplies, there are also reports challenging this underlying assumption of business as usual demand for more metals, more minerals. A second aspect to the authority's activity which we cover is that pursuant to those regulations, exploration contracts have been agreed, giving the green light for searching and analysis of deposits. Over 30 of these exploration contracts have been entered into, covering more than 1.3 million kilometres squared of the area. Those 30 contracts are shared between 22 contractors, including a Russian ministry and the government of India. And each contractor must have a sponsoring state, a requirement intended to promote compliance with the relevant UNCLOS obligations. China currently leads the charge on the sponsoring state stakes. It's listed as a sponsor on 5 of the contracts. As we were finalising our text, a new exploration contract was signed, and we had to update our figures accordingly, an example of how facts on the ground were evolving as we wrote. Third, in contrast to exploration, whilst no regulations have been issued with respect to exploitation, i.e. the extraction of the minerals, we do consider the draft regulations that are currently under consideration, totaling over 100 pages with accompanying draft standards and guidelines. This progress is coupled with strides in technology being reported. The Metals Company, which I referred to earlier, just this month announced that it has successfully lowered its nodule collector vehicle to the sea floor at a depth of nearly 2,500 metres, an example of what we refer to in the book as a trend of pressing forward. So against that backdrop, it is evident that there are hugely difficult issues with which we must grapple. Protection of the marine environment with respect to the exploitation phase is the big one. Three aspects are worth highlighting in this regard. First, and in stark contrast to the fast pace of technological developments, is the slow pace of recovery in the oceanic abyss. Close to freezing and almost no light, any disturbances risk being very long-lasting. Human timescales do not apply to this underworld's clock. Second is considering the sheer scale of the task in assessing potential for harm, not just the potential effects of the area of seabed, but casting much more widely, including to the water column, mid-water ecosystems. And it's not just potential of harm for currently envisaged mining techniques. As expressly noted in the authorities' revised recommendations to contractors for the assessment of possible environmental impacts, I quote, "It is likely that future mining operations will employ techniques not considered here." Third is grasping just how little we know about what is down there. A director of a marine conservation non-profit recently commented that much less than 1% of the deep sea floor has ever been seen by human eyes or with a camera. And a study this year in the Journal of Science Advances indicated that some 2/3 of the deep sea's diversity is unknown. One discovery that my 5-year-old daughter particularly liked hearing about, who, I note for the record, does not shy from giving me blunt feedback on when she finds my work stories boring, was a new species of octopus, thousands of meters below the sea, nicknamed Casper because of its ghost-like appearance, and laying its eggs on sponge stalks anchored to manganese nodules. The potential for harm to Casper's babies and the rest of the marine environment underpins the express obligation of the authority to pay particular attention to, and I quote from Article 145 of UNCLOS, a provision expressly cited in the draft exploitation regulations, to pay particular attention to the need for protection from harmful effects of such activities as drilling, dredging, excavation, disposal of waste, construction and operation or maintenance of installations, pipelines, and other devices related to such activities. So we see in Part 4 of the exploitation regulations, the drafts currently under consideration, is entitled Protection and Preservation of the Marine Environment. Divided into 5 sections, it addresses obligations relating to the marine environment, environmental impact statements, monitoring plans, as well as management of waste. And of course, there's the accompanying draft standards and guidelines. Concerns raised with respect to these drafts are wide-ranging and vociferous, including as to the development of binding and measurable normative requirements for the protection of the marine environment, and the process for integrating independent scientific input. An example of one specific concern that my non-scientific brain can get my head around is that of requisite baseline data, the importance of which was referred to by the New Zealand Supreme Court last year in a case concerning seabed mining within New Zealand's EEZ. So as you probably know, attempts to put a brake on cracking on with exploitation have crystallised with the moratorium on deep seabed mining. The central submission there is that before any mining occurs, it needs to be clearly demonstrated that such activities can be managed in a way that ensures the effective protection of the marine environment. It's not saying no mining ever, but rather let's pause until the risks and consequences have been fully investigated, to adjust our appetite for fast-paced accumulation to the rhythm of the darkest realm of the ocean. And it's interesting to see which entities have signed up to the moratorium. Amongst the list, which includes scientists, IUCN member states, is BMW, Volvo, Google, Philips and Samsung, and as of 2 months ago, France's Renault and US car maker Rivian. That moratorium initiative is to be contrasted with moves made elsewhere, or rather one significant recent move, that of the South Pacific nation of Nauru, who last year notified the authority of the intention of a subsidiary of the metals company, the company I referred to earlier, to apply for approval to begin mining, and thus triggered a 2-year rule buried in the implementation agreement. That rule, as you're probably aware, provides that following a request for approval of a plan of work for exploitation, the council shall complete the adoption of such rules, regulations and procedures within 2 years of the request. 2 years. Not the circumstances for which the rule was designed, one might say, and not sitting easily with the reported recent statement of SOAC, the company I mentioned merged to form the metals company, that we cannot predict whether the environment and biodiversity is impacted by our activities, and if so, how long the environment and biodiversity will take to recover. Whilst here in the UK, the FCDO has expressly stated that until there is sufficient scientific evidence about potential impacts and strong and enforceable environmental regulations in place, the government has committed not to sponsor or support the issuing of any exploitation licenses for deep sea mining projects. The prospect of huge swathes of our ocean being open to mining by 2023 currently remains firmly on the table. Perhaps if the world's media was not so saturated with horror and distractions already, more people would be discussing this round the dinner table. So there's a question mark left on what happens next with the exploitation regulations, what happens when Nauru's 2-year period expires, and whether its plan for work would in any event be approved, and more generally, how protection and preservation of the marine environment will be effectively achieved. As Germany stated at this year's session of the authority, we have the rare opportunity to effectively regulate a possibly large-scale human activity before it is implemented in practice, and we have the chance to do it right. This is a great responsibility. Thank you.
Thomas, you're on mute.
Thank you very much. Thank you very much, Amy, for shedding light on the deep dark seabed and for discussing some of the controversies around deep seabed mining. Finally, Vaughan Lowe will look into the future and speak about the main movements he considers will characterize the next few decades of international law in relation to the law of the sea. Vaughan, you have the floor, please.
Thanks very much, Thomas. If I can add my thanks to you and to everybody who's taken the time and trouble to log into this, and also to my co-authors. They took on an enormous amount of work, and I was grateful for the support that I had from them all the way through the task of preparing this 4th edition. They've shared their thoughts on the main developments in the law of the sea over the last 40 years. And I want to bring our presentations to a close by looking at the main developments that might be expected in the next 40 years. And by main developments, I don't mean the substantive developments such as the implementation agreements and the Convention on Biological Diversity. I'm thinking of more fundamental structural developments in the law of the sea. I sometimes think that there are 2 different meanings of the term law. To take a domestic example, there is the intricate web of legislation regulating road traffic, rules of the road, regulations on the care, construction, maintenance of vehicles, the laws on civil liability for accidents and so on. But I imagine that well over 95% of motorists never look up the law on any of these matters. Then there is the law that the drivers do know which side of the road to drive on, which speed limits to observe, not parking on double yellow lines, keeping the car in reasonable condition and so on. A handful of rules and principles that are the law as far as most motorists are concerned, and which in fact keep the traffic flowing. And it's this second, the driver's law, that I have in mind. Because for 2 centuries or more, the driver's law of the sea has been based on a simple distinction between maritime zones of coastal states on the one hand and the high seas on the other. You look at a map. If you're within a state's maritime zones, you're subject to its jurisdiction. National zones, coastal state rules, high seas, flag state rules, and that, with the qualification concerning innocent passage, was more or less it. It's true that the national zones might vary. It's barely a century since sovereignty over the territorial sea became firmly established, and fisheries, customs, and other activities have often had different limits. But the basic building blocks of the law of the sea were maritime zones. And I think that's changing in 2 main ways. First, the zones are increasingly overlain by a thick web of rules accepted by states that radically change the legal regimes applicable in those zones. One clear example concerns the high seas. The Proliferation Security Initiative and the associated bilateral shipboarding agreements that the United States has signed with a number of flag states means that over half of the world's merchant tonnage is liable to boarding and search by the United States. There are also comparable agreements between groups of states on rights to board ships, search them in order to enforce fisheries and customs and immigration laws. If one puts aside the theory of the exclusivity of flag state jurisdiction on the high seas and asks, in what circumstances might a state such as the United States wish to board a foreign ship on the high seas but have no legal right to do so, the position looks very different. Practically all the circumstances where the United States would wish to board, it can. And the same can be said of national maritime zones. For example, it's increasingly common for neighbouring states to claim rights to consultation and participation in environmental impact processes in relation to activities in the territorial sea and other maritime zones, and to claim specific rights to fish or engage in other activities there. And of course, UNCLOS, with its provisions on marine pollution and on the sharing of EEZ fish surpluses, makes a significant contribution to this development. So the basic framework of of maritime zones is being overlain with many specific rules that significantly alter the nature, the character of those zones. The second kind of change that I see coming up is an erosion of the very idea of zones and of boundaries of jurisdiction as a focus for legal analysis. One instance of this is the recent judgment of the ICJ in the Nicaragua-Colombia alleged violations case. There, in paragraph 160, the court held that, quote, the establishment by one state of a contiguous zone in a specific area is not, as a general matter, incompatible with the existence of the exclusive economic zone of another state in the same area. For the master of a ship ordered by a foreign law enforcement vessel to stand by and be boarded, the lesson is, don't look at the map to see whose zone you're in. Ask, does this flag state have rights to stop and search me here? Similar position on the high seas with the Proliferation Security Initiative. The Nicaragua-Colombia move is a small step, but as an approach to determining jurisdiction at sea, I think it has considerable potential. Another example concerns memoranda of understanding. In some regions, and I have in mind the Pacific and particularly the northwest area around the Spratlys and the Paracels, there's an increasing number of memoranda of understanding, often apparently limited to banal expressions of good neighbourliness, that states A and B are committed to the mutually beneficial development of trade or fishing or whatever. But what they do establish is a kind of locus standi. They make the point that state A should not simply build a new port or conclude a fisheries agreement with a third state. Rather, it should consult with state B, which has a legitimate interest in the way that state A exercises its rights in its own maritime zones. Now, this may be more a matter of process than of complete substantive rights, but process is often more important than substantive rights. For mortals, practically everything is process rather than a final result. It's hard to pin down what legal rights such an MOU would give state B, or what the limits of the resulting zone of influence of state B might be. But I suspect that in practical terms, this growth of soft law instruments as projections of soft power is likely to be one of the most significant developments relating to the law of the sea. So to conclude, when the 5th edition is prepared, I expect that the chapters on maritime zones will be smaller, and those on maritime activities will be longer, more numerous, and more important. And happily and coincidentally, those are the chapters that Robin writes for the most part. Thank you very much.
Thank you, Vaughan, very much for analyzing some of the fundamentals of UNCLOS and how they may be shifting and will be maybe shifting in the future. I hope these presentations have that some questions may have arisen as following these presentations by the 3 authors. But while we wait for those to come into the chat box, I have one question for each of the authors. First for Robin. So it seems to be generally recognized that it is important to preserve the integrity of the Law of the Sea Convention by maintaining its package deal from 1982 intact. However, at the same time, it has been emphasized that the convention and the Law of the Sea framework more generally must be a living instrument and adapt to new developments and challenges. How do you think these two goals have been reconciled, and what is your future prediction in this respect?
Well, thank you very much for that interesting question, Thomas, and not an easy one to answer in a short space of time. One approach might be to ask how the convention actually develops in practice and how far the process of that affects or relates to the package deal nature of the convention. One obvious form of development is the implementation agreements. And I don't think we need to be unduly concerned there about possible undermining of the package nature, because certainly the fish stocks agreement has a provision that it is subject to and to be interpreted in accordance with the convention. And I'm sure if any new agreement comes out of the current Intergovernmental Conference on BBNJ, that it will have a similar provision. Another way that the convention has developed and as a living instrument is through the work of the International Seabed Authority. It's possible to think there perhaps that it could adopt measures which would arguably affect the package deal nature. The introduction of a moratorium on seabed mining, for example, might be seen by some states as undermining the package deal nature of the convention. The package deal nature of Part 11 when read with the 1994 agreement. My feeling probably is that the decision-making processes of the authority are such that it is unlikely that the package deal nature would be disturbed in a way that didn't have widespread support from states parties. Then another form of development is through judicial interpretation. And again, I think international courts and tribunals are sensitive to the package deal nature of the convention, though I suspect as time goes on, that will become less important, just as with older treaties, the intentions of the parties at the time of drafting tends to decrease in importance. And then another form of development, as I suggested earlier in my remarks, is through the resolutions of the General Assembly. And again, I think if the package deal nature of the convention is undermined there, then it will be with the consent of all, if not most, of the parties. So to my mind, the biggest threat to the package deal nature, or if you like, the various compromises of the convention, arises more from unilateral action, particularly unilateral action on some scale. For example, if we take the question of passage through archipelagic waters, I think one can say that the agreement of maritime states to the whole concept of archipelagic baselines and archipelagic waters was as a quid pro quo, or the quid pro quo for that was archipelagic sea lanes passage through routes normally used for navigation. If archipelagic states suddenly began to refuse to accept archipelagic sea lane passage, then that would certainly undermine the package deal nature of the archipelagic regime. But of course, it would all be contrary to the convention. Another point that occurred to me too is that it's conceivable that some package deal elements could be undermined simply by changes in desirable policy. If we take the outer limits of the continental shelf, I think it's fair to say that Article 82, which provides for revenue or some share of the revenue from the exploitation of the resources of the outer continental shelf, the continental shelf beyond 200 miles, that provides for such revenues to be shared by the international community, was a quid pro quo for states being allowed to extend their continental shelves beyond 200 miles. It's clear, I think, from all the recent reports on climate change, and also a very important report from the International Energy Agency last year, that there has to be a moratorium very soon on the exploitation or exploration of new fossil fuel resources at sea. And one might argue that if such a moratorium came into being, which is certainly desirable, then that would at least reduce, if not end, the kind of revenues that might be available under Article 2. And that would clearly undermine the package deal nature of that provision. I think you're muted, Thomas. I think you're muted.
Yeah, thank you very much, Robin. But I'm so sorry. Thank you very much, Robin. I just had a thought, because you referred to Article 82, that of course it applies to non-living resources generally. So who knows what the future holds in terms of resources? We always think we are on the top of the knowledge, but if we look at
yeah, that's why I clearly said reduce the possibility of revenue.
Yeah.
But yes, it's possible.
But I think it's something. Yeah. I think it's something to have in mind, generally, that we always consider we are kind of on the top of things, and then we look at how much we know now that we didn't know 40 years ago, that probably in 40 years it's going to be something similar in terms of the changes that take place. So I have a question now for Amy Sander. You referred to the protection of the marine environment in the context of deep seabed mining, and there's a lot of controversy there, obviously. What effective enforcement mechanisms, if any, are available with respect to prevention of harm to the marine environment? What mechanisms are available to keep the contractors in check in this respect?
Thank you. I think there's two strands to the question. The question of what mechanisms are available, and then the second question of, are those mechanisms effective? And as to mechanisms that are available, if I focus on the authority who is mandated under UNCLOS to exercise such control over activities in the areas as is necessary for securing compliance with the relevant provisions of UNCLOS and the regulations and rules, and a control indeed that is expressly accepted by the contractors, we can see different ways in which that exercise of control is elaborated in the legal framework. So, for example, there are notification requirements for contractors in instances of harm to the environment. The council has the power to issue emergency orders, adjustments, suspension of operations, and ultimately the council may terminate a contract or terminate a contractor's rights or impose a fine in cases of serious, persistent and willful violations of fundamental terms. One power that I think is quite interesting that the authority has is with respect to inspection, with the council authorised to establish a staff of inspectors. The exploration regulations expressly provide for inspectors to board vessels and installations, but the powers, it seems to me, in the draft exploitation regulations are more extensive. For example, prior notification of the inspection may be dispensed with in certain circumstances, and the inspector's powers expressly extend to seizing any document, article or substance that the inspector reasonably requires. Although I see those are two provisions that got pushed back in the March negotiations. China was on the record with the deletion on both of those. And it seems interesting questions then are yet to be finalised on who the inspectors will be, how and when they'll be appointed, how they'll be paid, a complaints process procedure, how that'll operate. One of the amends I saw from the session earlier this year was for a code of conduct, raising questions of how principles of independence, transparency, accountability, conflicts of interest are to be managed. So moving to the second part of the question, how effective? Headline point is gaps and question marks, it seems to me. On prospecting and exploration, certainly in 2018, the Secretary General reported that no enforcement action had yet been taken by the Council. With respect to the draft exploitation regulations, the rules for inspection, compliance and enforcement were expressly raised by 10 states in a letter to the authority at the end of last year as one of the issues on which delegations were far from reaching an agreement. There's the informal working group on inspection, compliance and enforcement. I didn't find huge amounts of information on this group on the authority's website, but looking at what the textual proposals were being made from participants in the March-April sessions reveals fundamental unresolved issues, and indeed a plethora of those. And I saw that there were at least a couple of states calling for a separate compliance committee independent of the Secretary General. So the question of the enforcement mechanism to be in place seems very much a work in progress. And of course, this is against the backdrop of potential vast scale and irreversible environmental damage. So the stakes are high, and it certainly doesn't seem to be a process that can be rushed through at all.
Thank you very much, Amy. Then I have a question for Vaughan, finally. So this is also a bit about the changed circumstances and the future. So when the convention was drafted, climate change was obviously still not high on the agenda. It wasn't totally unknown, but certainly not high on the international agenda. And there is no reference in the convention, for example, in part 12 to the emission of greenhouse gases and to climate change. Now, this notwithstanding, in your view, should the interpretation of obligations of states to protect the marine environment under Part 12 take into account new scientific findings and changing environmental circumstances to include also the emission of greenhouse gases? Vaughan, please.
You're muted, I think, Vaughan.
Future generations will not have this problem, I'm sure. It must do. It would be absurd to suggest that the convention should be interpreted using only the science that was available in 1982, and developments in understanding of what amounts to pollution, what the effects of pollutants are, developments in oceanography and understanding of the way that the waters in the oceans behave, must all be taken into account. I can't see any conceivable argument to the contrary from that. As far as greenhouse gases are concerned, that too seems to me to be a very obvious case where it must be taken into account. And the convention refers to the pollution of the sea. Most pollution of the sea does not come from the sea, it comes from elsewhere. And there is nothing in the convention that would limit it to pollution that gets into the sea by particular pathways, and it would be an arbitrary and, to my mind, absurd result to suggest that it should be limited to what? To material that's dumped at sea, or to material that gets into the seas through river runoff or through sewage pipes deliberately pumping material out into the seas? No, and I think it must all be taken into account. The question for me that I think is more interesting is where you go from that point. And if you look, for example, at the provisions in the Convention on Monitoring and Environmental Assessment, which contain very general obligations about monitoring activities that may lead to marine pollution, informing other states and so on. If you take the view that every car exhaust that is putting out gases is contributing to marine pollution, which is a matter of scientific fact and causation, is undoubtedly true, then potentially those parts of the convention have the possibility of encompassing all polluting activity. And it's possible that states could try to bring all forms of pollution within the convention. Now, that may not matter much with many conventions, that kind of expansion. But in the case of UNCLOS, where you've got the Part 15 dispute settlement procedures at play, the possibility of using UNCLOS as a mechanism to handle disputes over marine pollution and international relations generally in matters of transboundary pollution, I think is a very interesting question. There's going to have to be some very hard thought devoted to exactly how the breadth of application of UNCLOS is handled and implemented in practice.
Thank you, Vaughan. Thank you very much. We have a question. We have actually two questions from a William George, PhD, Emeritus Professor of Theology from Dominican University. I think the first question probably would be suitable for Robin. He's asking, as you evaluate the law of the sea since the adoption of UNCLOS, in what ways do you think it has become stronger or more effective, and what remains its weakest or least effective aspect or area? So what are the strengths of in the development of the law of the sea over the last 40 years, and what are the weaknesses? Robin, would you care to respond? This is related, I think, to what you have already been talking about.
Well, one answer would be to go away and read the recent House of Lords report on whether UNCLOS is still fit for purpose. There's a lot more than I can possibly say now, but in my view, the strength of UNCLOS One of the main strengths of UNCLOS has been that it has laid down a jurisdictional regime which has basically stood the test of time. If one thinks about the situation before UNCLOS in terms of claims to maritime zones beyond the territorial sea, then we now have, I would say, reasonably good order where before there was chaos and dispute. I think another strength of UNCLOS has been the dispute settlement provisions. There may not have been that many cases, but the fact that it's there in the background, I'm sure, must influence the way in which states behave. Having said that, almost a contradiction of that, there has been quite a lot of widespread non-compliance with UNCLOS in various ways. I think the fact that it's failed to grapple really with substandard navigation, for example, that the many of the provisions on fisheries management depend really on states and their self-interest and indeed also their altruism, rather than on the duties in the convention which can be easily enforced. But maybe, I say, go back and have a look at that House of Lords report, because to answer the question fully, we would be here all afternoon.
Thank you, Robin. I just had the thought that, because you mentioned the dispute settlement mechanism, and I guess given the geopolitical situation in recent years, it's probably not, it would not be realistic probably to reach the same level of compulsory dispute settlement mechanisms if UNCLOS were to be negotiated today. So I guess we better keep it. But I have another. There is another question from William George also. The question is, who of you would like to respond? So he is asking, what difference would it make if the United States finally became a party to UNCLOS?
I can't imagine
Anybody?
that any of us really wants to answer that question. And for me, it's not a legal question. The main answer would be that it would be a sign of commitment to an agreed world order which aims to provide the framework for dealing with problems that are truly global, and the real signal that the United States would send of its commitment to that scheme, I think, would be an important one.
Thank you, Juan. We are precisely on the hour, and I don't see any questions in the chat. So I think we should call it a day. I thank you so much, Robin Churchill, Amy Sander, Vaughan Lowe, for giving the time to present your fourth edition. Obviously, there's a lot of quantity there, but I'm sure that quality goes hand in hand with that quantity. And I want to congratulate you heartily on the book. I'm in Athens at the moment, traveling, but of course I brought it with me. So I hope as many of you as possible will have this book that I'm sure will be just as much a key textbook in the law of the sea as it always was. And this is really the book that I grew up with. So I couldn't really separate between the convention and this Bible. I always had these two when I was doing my first studies. So thank you all very much for your attendance. And
thank you very much, Thomas.
Have a nice day. Thank you.
Yes, thank you, Thomas.
Thank you.